Hello everybody, selamat Hari Raya semua. Gang AmerBON is back this week. So harap semua tengah, enjoy lemang-lemang and all the ketupat and rendang. So our speakers today, as you can see, Amir Hamzah, New Sinu, Joshua, Michael, and Sue. So today, Josh will be speaking about whether it's desirable to have online proceedings when it comes to criminal matters. And then follow up with Sinu will be talking about contracts. And then Mike will be talking about employment issues. And Sue will be talking about rent control and also landlord and tenant relationships. And Amir will be talking about the COVID bill. All right, so let's start with Joshua.
Hello everyone. Selamat Hari Raya. Jadi hari ni saya nak cakap pasal isu pendengaran online bagi kes-kes mahkamah, terutamanya bagi kes khususnya bagi kes jenayah lah. Dan baru-baru ni kalau kita ada baca di social media atau di berita terdapat laporan berita di mana di Singapura di mana seorang warga negara Malaysia telah dijatuhkan hukuman mati bagi kes pengedaran dadah melalui aplikasi Zoom atau melalui online lah, proceeding online. Jadi terdapat banyak atau ramai pihak-pihak yang telah perkara ini telah menarik perhatian ramai pihak dan terdapat banyak kritikan atau komen berkenaan isu pendengaran kes-kes jenayah melalui secara online. Jadi pertama sekali bagi isu yang paling asas bagi saya berkenaan pendengaran online bagi kes jenayah adalah berkenaan isu keterbukaan. Secara lazimnya bagi suatu proceeding mahkamah ianya perlulah open, terbuka kepada orang awam. Perkara ini telah pun termaktub dalam kanun prosedur jenayah kita, tak silap saya section 4 yang menyatakan bahawa courts have to be open to the public except in certain situation. Jadi dalam bahasa Melayu, mahkamah perlu terbuka secara lazimnya, mahkamah perlu terbuka kepada orang awam, melainkan atau kecuali terdapat dalam beberapa situasi, mungkin bagi kes yang melibatkan kanak-kanak atau kes yang melibatkan rahsia kerajaan. Jadi dalam situasi sedemikian, mahkamah boleh menjalankan perbicaraan atau kes secara tertutup atau secara dalam litar melalui kamera. Dan rasional atau sebab mengapa mahkamah perlu terbuka kepada orang awam adalah untuk memastikan ketelusan atau transparansi proceeding. Jadi orang awam boleh pada bila-bila masa mahkamah sedang bersidang boleh datang ke mahkamah dan melihat proceeding mahkamah, untuk dan memastikan bahawa tiada hengki-pengki lah atau perkara yang tidak wajar berlaku di mahkamah. Dan bagi pendengaran online, perkara ini akan berkait dengan pendengaran online kerana terdapat situasi di mana di negara luar lah, contohnya terdapat situasi di mana pendengaran online tu diadakan tetapi orang awam tidak, atau orang yang mempunyai kepentingan di dalam suatu kes mahkamah tidak dapat menghadiri atau mendengar proceeding tersebut. Jadi di Malaysia baru-baru ni bagi satu kes civil di Mahkamah Rayuan, pihak mahkamah atau pihak judiciary telah melaksanakan satu pendengaran online, dan saya rasa the effort has to be lauded lah. Saya rasa yes, it's a step in the right direction, di mana pendengaran online tersebut dihadiri of course oleh hakim, peguam, dan proceeding tersebut juga telah diterbitkan atau ditunjukkan secara live di YouTube, di mana orang awam atau sesiapa yang berminat untuk mendengar pendengaran tersebut boleh menontonlah proceeding. Tetapi saya rasa bagi kes tersebut admin telah menutup atau off the comment section bagi video tersebut. Jadi that is an alternative. Ia merupakan satu alternatif di mana untuk memastikan proceeding mahkamah masih boleh diadakan secara terbuka di mungkin YouTube atau Facebook dan sebagainya. Tapi bagi saya pendengaran online bagi kes jenayah lebih penting, atau isu yang lebih penting bagi pendengaran online berkenaan kes jenayah adalah isu berkenaan demeanor, terutamanya bagi kes perbicaraan. Jadi salah satu aspek penting dalam perbicaraan adalah demeanor of the witness, atau tingkah laku atau gerak-geri seseorang saksi apabila memberi keterangan di mahkamah. Dan bagi seseorang hakim, kanun tata cara jenayah atau kanun prosedur jenayah telah mewajibkan seseorang hakim untuk membuat nota berkenaan demeanor atau tingkah laku atau gerak-geri seseorang saksi. Dan apabila saya kata demeanor atau tingkah laku seseorang saksi ini, ia mungkin melibatkan kegelisahan seseorang apabila ditanya atau apabila menjawab sesuatu soalan, dan mungkin terdapat juga tingkah laku yang bersifat evasif atau apabila saksi tersebut cuba mengelak untuk menjawab sesuatu soalan. Dan bagi saya pendengaran online ni, it takes away atau it diminishes the value of this aspect of this criminal trial. Sebab mungkin saksi tersebut boleh kata, saya kurang selesa apabila memberi keterangan melalui online kerana saya tak biasa dan sebagainya. Kemudian terdapat juga kemungkinan apabila seseorang saksi memberi keterangan di mahkamah, saksi tersebut mungkin boleh merujuk kepada suatu dokumen ataupun boleh dilatih atau dibantu oleh seseorang yang tidak dapat dilihat di dalam kamera. Jadi contohnya apabila saya sedang bercakap ni, mungkin saya boleh merujuk kepada satu dokumen yang penonton tak nampak. Jadi terdapat juga kesukaran atau masalah praktikal dari segi pemberian keterangan oleh seseorang saksi. Kemudian masih berkenaan isu demeanor juga adalah, bagi saya lah, melalui pengalaman peribadi saya, adalah demeanor seseorang hakim atau demeanor peguam lain ketika perbicaraan atau pendengaran online tersebut berlangsung. Sebab kadang-kadang apabila kita hujah atau kita membuat pemeriksaan, sama ada pemeriksaan utama, pemeriksaan balas atau pemeriksaan semula, kita melihat pada hakim dan untuk memastikan sama ada hakim mengikuti soalan atau memahami apa yang kami cuba sampaikan kepada mahkamah. Jadi perkara tersebut juga mungkin akan terjejas bagi pendengaran secara online. Perkara ketiga pula, terutamanya bagi kes perbicaraan jenayah adalah berkenaan aspek pemeriksaan bukti atau eksibit. Jadi terdapat situasi di mana mungkin peguam bela atau peguam-peguam perlu atau even hakim perlu memeriksa atau melihat sesuatu eksibit. Jadi contohnya mungkin dalam satu kes bunuh terdapat sebilah pisau yang dikatakan digunakan dalam kes bunuh dan dikatakan ada kesan darah pada bilah pisau tersebut. Jadi dalam keadaan sedemikian, kebiasaannya pihak peguam akan dan juga hakim akan melihat atau memeriksa sama ada betul atau tidak terdapat kesan darah pada bilah pisau tersebut. Jadi bagi pendengaran online kita akan mengalami kesukaran daripada aspek inilah. Bagaimana kalau siapa yang akan memegang eksibit tersebut dan bagaimana pihak pendakwaan, pihak pembelaan atau pihak mahkamah boleh memeriksa atau memerhatikan sesuatu eksibit. Dan isu keempat adalah isu komunikasi di antara peguam dan anak guam. Jadi kadang-kadang di dalam kes perbicaraan jenayah terdapat isu baru yang ditimbulkan oleh sama ada pihak pendakwaan atau mana-mana pihak ataupun oleh saksi ataupun even pihak mahkamah. Dan dalam situasi tersebut, peguam bela perlu mendapatkan arahan daripada anak guam dan biasanya kami akan meminta kebenaran daripada mahkamah dan atau meminta satu penangguhan yang singkat, short stand down untuk mendapatkan arahan daripada anak guam. Jadi bagi pendengaran online, saya rasa ini adalah salah satu masalah yang bakal atau akan dihadapi oleh anak guam dan pihak pembelaan kerana tiada avenue, tiada platform untuk anak guam berkomunikasi dengan peguam bela. Dan komunikasi tersebut biasanya di antara seorang peguam bela dengan anak guam, dia terlindung dengan isu privilege. Jadi subjek atau subjek komunikasi di antara peguam dengan seseorang anak guam itu terlindung dan tidak boleh tidak boleh dimaklumkan atau tidak boleh didengari oleh pihak-pihak lain seperti pihak mahkamah atau pihak pendakwaan. Dan perkara terakhir ialah isu terakhir atau masalah terakhir ialah masalah teknikal dalam pendengaran secara online. Ini melibatkan mungkin internet connection yang tak berapa bagus, jadi terdapat lag atau delay apabila proceeding mahkamah berlangsung. Dan mungkin juga terdapat mungkin dalam proceeding mahkamah terdapat isu komputer mengalami masalah atau sebarang perkakasan, mungkin mic atau mikrofon atau kamera mempunyai masalah, jadi ia akan menjejaskan kesinambungan atau continuity of the court proceeding. Jadi mungkin bagi semua mahkamah di dalam dunia, mungkin perkara ini masih merupakan perkara baru yang masih dipelopori atau masih dieksplor oleh pihak-pihak yang terlibat dalam industri perundangan. Tapi secara kesimpulannya bagi saya, penggunaan sistem online dalam prosedur mahkamah bagi kes jenayah terutama ataupun bagi kes mahkamah sama ada sivil atau jenayah merupakan satu perkara yang bagus lah, satu step in the right direction, tetapi mungkin ia perlu dihadkan bagi isu-isu yang non-contested atau tidak dicabar, mungkin seperti pengurusan kes atau sebutan, mungkin juga bagi kes-kes aman trafik. Sebagai permulaan, mungkin pihak mahkamah boleh menggunakan aplikasi online untuk melaksanakan proceeding tersebut. Tetapi bagi kes, bagi perbicaraan atau pendengaran secara online, mungkin belum sesuai lagi untuk menggunakan aplikasi online. Jadi itu saja yang saya nak ulas berkenaan isu pendekatan online bagi prosedur mahkamah. Kalau ada apa-apa soalan, boleh ditanyalah di bahagian komen dan kami akan cuba jawab soalan tersebut. Terima kasih.
Okay, terima kasih Joshua. Jadi kita orang boleh lihat mahkamah memang kena guna IT sebagai alternatif untuk menjalankan perbicaraan, tapi perlu mempertimbangkan banyak faktor-faktor lain lah dan kesukaran yang lain. So seterusnya we will have Sinyu that will be talking about contracts. So Sinyu, please.
Thanks, Shara, for that. Yeah, so this week we'll be talking about COVID-19 bill and what should be inside. And Josh has spoken about, the need for having IT in the court proceedings, as well as how it's going to affect the criminal trials. So that's definitely one aspect of what should be included in the COVID-19 bill. I think before I go into detail as to what contractual obligations should be governed by the court, sorry, not by the court, by the COVID-19 bill, it's probably worth pointing out that this COVID-19 bill is not, it can be one specific form of legislation, or it can be an amendment towards many existing legislation. The form can take either one of those two. It doesn't really matter. But what's important is the areas that should be covered by a COVID-19 bill or bills. And it should be as inclusive as possible. It should be as comprehensive as possible. It shouldn't only govern businesses. It should also govern employees, and it should govern those who have been disproportionately affected by the pandemic, especially the working poor and the vulnerable minorities. So it should be something that is available to all segments of society, or intersection of identities. And everything is, especially when you talk about contract, everything is based, because we live in a capitalist system, so everything is based on the assumption that we will have income. And a lot of contracts, especially loans, hire purchase, is based on the assumption that you are going to have income, and you will be able to fulfill your contractual obligations as a result of you entering into that contract. So when a pandemic happens, that very assumption is displaced, because suddenly businesses and individuals, their income have been affected, their income has been suspended. So it wouldn't be fair for one party to the contract to be able to take advantage of, or to be able to blame the other party for non-performance of that contract. as a reason if the other party has been affected by the pandemic. Of course, I'm saying this, it doesn't mean that every form of contract or every area has been affected by the pandemic. And you have to take into account certain socio-economic considerations as well. Because if employers are allowed to suspend contracts of employment, then the working poor or those who are entirely dependent on their employment in order to survive, they would be disproportionately affected. So when it comes to a legislation like COVID-19, that should be in the forefront of the government's mind. How do we best protect those who have been disproportionately affected by COVID-19? And it's really a question of limited resources, isn't it? Because at the end of the day, the government doesn't have unlimited funds. All the government has for now is 250 billion allocated. So this 250 billion won't be sufficient to cover everybody. And we got to ask ourselves this question, that who should first to benefit from this allocation of 250 billion? And I think that is quite obvious. It should be those who have been disproportionately affected, especially the working poor, because the others, upper middle class or business owners, they would have funds, or they would have more of a cushion compared to them comparatively. So let's deep dive into contracts. When you talk about contracts, well, it basically covers almost every aspect of commercial life, doesn't it? So a COVID-19 bill, I think, would have to deal with the following aspects of contract. First, let's talk about the common contracts. The first in mind is housing contracts. What do you do with SPAs? Because SPAs, time is of the essence. So it runs on certain timelines, run on certain deadlines. And we have seen constructions halted because they're not able to commence work or continue work during the pandemic, during the MCO. So this issue of late delivery of properties, especially LAD, I think would be something that the COVID bill would have to touch on. So when it comes to damages arising out of LAD and deadlines, I think all those, it needs to be suspended, and LAD shouldn't be allowed to be enforced or recovered during that period of the pandemic, where the contract is incapable of being performed because workers are not able to work. So that's one thing, SPA. And then you have another common form of contract, hire purchase contracts. So hire purchase contracts, we have a moratorium, and I think the banks have agreed to impose or agree to a moratorium of 6 months, where you don't have to pay your monthly installments, and there wouldn't be any interest charge on it. I think that was agreed in the most latest announcement. But I think a COVID-19 bill would need to put that into law as well, because this moratorium, I'm not sure of its legal effect. So the bank, could make could decide to change their minds, where after 2 months and say that, I think we are going to charge interest on top of that, because we did see some flip-flop earlier on. So it's important to cement that position into law and allow this moratorium to have legal effect. So hire purchase contracts, yes, that's definitely something that should be covered. Another common contract is tourism-related contract, because tourism have came to a complete halt. So tourism-related contract, this whole idea of frustration of contract, force majeure, it shouldn't be left to something that parties to the contract should interpret whether or not it falls within those two clauses. The government, parliament should take the lead by stating that where it is related, where the inability to perform a particular tourism-related contract or any contract for that matter is due to a pandemic, then the contract is deemed to be suspended, or the obligations of a contract is deemed to be suspended for the duration of that pandemic, or whatever period that the government thinks that businesses would and parties to a contract would have enough time to get to their feet. That would involve bookings, bookings you make with the airlines, booking you make with the hotels, with your travel agents. I think that bookings, there should be some form of guidance here, because it affects both sides. Businesses need that payment. They may not be able to make that payment back to you, so that's something that government should consider as well. And those who have made their bookings, they may want that payment back, because it's very times are tough. You need every penny that you have. So bookings, sign documents online. A lot of contracts, they require witnesses to be present, and obviously witnesses can't be present, and the advocate and solicitor cannot be present because of the MCO. So some have taken it online, where you are satisfied yourself as to the identity of the parties. So that's something that should be allowed under this new COVID-19 bill. Limitation Act, a lot of contracts, where there is a breach, it needs to be enforced. You need to file a case in court within 6 years. So sometimes there are cases where it runs too close to the 6 years. That is something that should be looked at as well. You need to extend the limitation period. It's not just contracts really, it's tort and almost everything else except for certain causes of action. And then you have supply contracts. Because of the restrictions against travel, some businesses, they may not be able to supply goods where promised. So that's something that should be suspended if it is caused by the pandemic. I think the underlying idea here is that everything should be put to a freeze. If the breach of the contract, or the future breach of the contract, anticipated breach of the contract, is caused by the pandemic. And I think there are definitely more, but I think suffice for now. That should be suffice for now. I think Mike will talk about employment-related issues in the COVID-19 bill later. Thanks.
Thank you, Sinyu. Yes, I agree that the COVID bill should also deal with contracts. So especially hire purchase contracts. Who knows, bank will U-turn, say cannot delay payment and all. So next will be Michael, who will be talking about employment issues during this pandemic. Okay, thanks, Mike. Mike, you're muted.
Hi, everyone. Hi. Okay. I think I'll be talking on what I think should be in the COVID bill, or supplementary to the current employment laws to deal with the existing employment issues. First is when we have a law which allows for employers to suspend contractual obligations. This now Sinyu went extensively on it earlier, where it would eventually allow for employers to, in a way, cut down on their expenses. Okay, and they would have cash flow. But at the same time, I think the law must also provide protection for employees in that suspended period. For example, if examples of protection can include, for example, employers must retain the employee during that suspension period and should not be allowed to terminate the employees, save for very exceptional circumstances where there is a serious misconduct. All right, so that's one protection that can be there. Or another protection is that they cannot deduct their salaries or force them to go on unpaid leave. So I think the government or the legislators in contemplating on deciding the COVID-19 bill should also take into account the to protect the employees, because this is necessary, because it is unfair if some employers who would benefit from this suspension of contractual obligations, but at the same time to save their business, but at the same time employers are being let go and their livelihoods are being affected. So I think it's a very important point, important for the drafters of this COVID-19 bill to look into this aspect also. All right, so this one aspect which should be covered in the COVID-19 bill. Secondly, I noticed a news article shared online recently that a person was not allowed to file his representation to the Director General of Industrial Relations for wrongful termination because he was out of the 60-day deadline period. So when a person is being terminated, from day of termination, he has 60 days to file his representation for wrongful termination to the Director General of Industrial Relations. But this guy was not able to do it because when he was terminated, the country was under strict MCO, and the Department of Industrial Relations was closed when he went there, so he was not able to make any claim. So, but when the MCO restrictions were slightly released, slightly relaxed, he went there, and then he's not able. They said that he's already passed the 60-day deadline, so he was unable to make the claim. So, I think the COVID law can address this by retrospectively permitting people who were terminated when the MCO started until a specific period of time. So it gives a leeway or some room for people to file claims for wrongful termination, okay, because of the MCO and because they were terminated at that period of time. So that is to deal with those people who have been terminated then, and in addition to that, increase the 60-day period to a longer period, for example, 90 days, so that people have more time, to seek legal advice and to make representation in light of this new norm. Because, as everywhere we go, the lines are long, there's a longer waiting time, and it's not easy to make face-to-face contact to meet your legal representatives and all that. So I think certain leeway must be given an extended period of time so that people can make that representation to the Director General of Industrial Relations. Okay. Further to that, I think in terms of industrial relations proceedings, it should also be explicit in law, rather than Department of Industrial Relations saying that okay, you can submit your representations by email. The law should make it clear that they should be allowed to make such claims online, maybe for a specific period of time, during the period of time where the government says deems is necessary. Okay. And with the new norm, the new normal, people are not able to meet face to face each other. So in the whole industrial relations proceedings, there is this part of reconciliation process where employers and employees must come together with the representative from the Department of Industrial Relations and try to reconcile, find a middle ground or try to resolve the issue between them. So maybe the law can also explicitly provide that such meetings should be or can be done online if parties agree. Because I think it'll be very difficult if for some people who are away in a different state but have been terminated, they are not able to go to the to where they are, where the complaint is being filed for the reconciliation process. Okay, so that is one thing that the drafters can take into account. The other thing that drafters can take into account is the place where where the employees can file their representations to the Director General of Industrial Relations, because under the Industrial Relations Act, they are supposed to file it at the place where it's closest to their place of work of employment. But I think the law should be slightly relaxed to allow them to file it at any department of industrial relations. So that leeway should be there. And also, I think to follow up on Joshua's point made earlier, maybe the drafters can also consider having provisions to allow for industrial court proceedings to be done online. Okay, so that's one aspect. That's another aspect which can be seen in terms of industrial relations proceedings, which can be added into the COVID bill. Thirdly is I spoke about this last week. For the COVID bill, maybe we can also have a provision where the federal government is able to take over private businesses for the national's interest, like nationalisation. Okay, so for example, Section 114 of the Water Services Industry Act, or in short, WASIA, allows minister to determine in the national's interest to direct the National Water Services Commission to take over a company registered under WASIA in whole, at the whole company, or in part. So what happens when the commission takes over? It can take over the whole property, business affairs of the company, or just part of it. So for example, it can be like if it's for the whole company, it's quite obvious. But if it's for part company, for example, if it's a main company has a subsidiary company, and that subsidiary company has produces or can be used to produce specific materials or products or services which are essential to the company to the country, and the government thinks it's necessary to take over it so that they have control, and that services or product is being generated more efficiently for the country, or if the company is dying and the government sees as a need to support it, then it can take over that small branch of that particular company and carry on with the businesses and affairs. I think this is important to also. This is also a way for the government to boost the economy and also to protect employees in such difficult times, because we do not know what will happen even if your company provides essential services. Okay, so that's the third one. In terms of the fourth thing, which I think is last year, there was an amendment to the Industrial Relations Act, which was passed by the end of 2019, but it has not yet been enforced by the minister. So further to the COVID-19 bill, I think the Minister of Human Resources should enforce certain parts of the new amendments to expedite wrongful termination claims and representation. Firstly is the shifting of power. For example, shifting of power from the minister to the Director General of Industrial Relations to refer in unfair dismissals to industrial court. This would free up the minister from a lot of time to deal with more sort of high-level determinations or policies, while the Director General can take over this big part of his work, so that the minister will not be bogged down, and because the minister already has so much to do. So this process will expedite this shifting of power will expedite the industrial relations procedures. Okay. So secondly is also if the matter during the reconciliation process cannot be resolved under the current existing laws, is that the minister may, if he thinks it's necessary, to refer it to the industrial court. But under the amendments now, it says that if it cannot be resolved, the Director General shall refer it to the industrial court. So I think this, when it says shall, it gives the it is mandatory. So if the Director General, there's no further consideration that has to be done. He has to immediately refer it to the industrial court. So this saves the time for Director General to pass it to the minister to consider, think about it, yes or no. This is a straightforward process. So the Director General will just see if it cannot be resolved, then he directly refer it to the industrial court. for determination. So yeah, so that will very much quicken the process of representations for wrongful termination. The other point which I think the minister can enforce, the other point of law, the other amendment which the minister can enforce is appeals. So which is after a determination by the industrial court, usually what will happen is the person agrees, the person who has lost may want to challenge the decision of the industrial court, but he cannot do it by an appeal, like how normally in normal civil cases or criminal appeals, you straight away just file an appeal to the higher court. In industrial relations matters, the person who lost would have to file a judicial review. So it's a separate procedure altogether. And in a judicial review, the the court that is listening or determining the judicial review cannot look into the merits of the case, but has to look at what errors has the industrial court chairman made. So it is very limited in terms of the scope of what the high court judge when he determines the judicial review. But in an appeal, if it's an appeal, the appeal process is much shorter, because all you have to do after the industrial court award is being given is to file a notice of appeal at the high court. Okay, so file a notice of appeal in the high court, and there's no need to draft further pleadings, like to draft all the documents required to file the judicial review. So this one, immediately just file a notice of appeal, which is a very short document, file a notice of appeal, and then after that, the high court who will be hearing the matter can not only look into what the industrial court chairman did wrong at the industrial court level, but he can also look into the merits of the case. So to look at the case as in totality, not just what the industrial court chairman said wrong. So he can look into the facts, he can look into other matters, everything is in the interest of the party, and look at the evidence as a whole. Okay, so then to determine the case. So that is what can be done. Those are the areas which I think the minister can enforce immediately during this period of time, so that the cases go much faster. All right, so because livelihoods are affected, so the cases need to go quite fast. Lastly, I think it is necessary to also increase the penalty against employers who fail to comply with the prevention and control of infectious disease regulation, because now the current fine is just 1,000 ringgit. So for people to comply, to make sure that they comply with social distancing, they comply with having proper sanitation and all that, I think the fine should be increased. So yeah, that's about it. If you have further questions, feel free to ask in the comment section. Thanks.
Thank you, Mike. That was very informative. So yes, I agree that the bill should sufficiently address on employees' protection and also online hearings and online filing when it comes to claims. So next off, we have Sue, who will be talking about rent control and also relationships between landlords and tenants. So please,
hi everyone.
Sue.
So actually, this rent situation is sort of a follow-up on also it's a part of contract which Sinyu talks about. So during this COVID-19 situation, there are tenants who are negotiating with their landlord whether they can have their rent reduced, or whether they can suspend their tenancy agreement, or have a grace period for them to repay the rent, or just don't suspend their contract just because of non-payment. So this issue, for this issue, I think the government should look into a few things before implementing to put in a COVID law. So number one is that one consideration is that the government maybe can have a regulation to suspend the tenancy agreement during this COVID-19 period. And for example, like this suspension is only applicable to tenancy agreement that was entered or renewed from February 2020 or maybe January 2020, so that people won't actually abuse this suspension. Another consideration that the government should have is that maybe to have a moratorium for a period of time for the tenant to pay up the landlord. So for example, 6 months or maybe 9 months. So that's another consideration that the government should look into when when trying to come up with COVID law on rental. And then the next consideration that I think the government should implement is that landlord cannot terminate the tenancy due to non-payments of rent. And they shouldn't exercise their rights to come in and claim back their land and just kick out the tenant. Because in this situation where everybody is facing a very difficulty, having a place to stay is it's like somewhere they can feel safe and all. So if the landlord actually just terminate the tenancy agreement and kick them out, it's actually basically asking them to just stay out, to be out and expose themselves to this virus. So, and then the next consideration that the government can also look into is the rent control. So Malaysia is actually not foreign to rent control. In the 1960s, we actually have a Rent Control Act 1966, but was abolished in the year 2000. So this Rent Control Act was applied in the heritage areas like Georgetown, Penang. So under this act, owners of the pre-war buildings, which are those houses built before 1948, were not allowed to increase rent indiscriminately. So initially, when they have this Rent Control Act, it was to regulate and control the rental of privately owned buildings that was built before 31st January 1948, because there was shortage of housing during the post-war period. So having this Rent Control Act is to make sure the landlord doesn't spike up the rental. So during that period, the rental was really cheap. The rental was about 10 to 25% of the amount if there was no rent control. And under this Rent Control Act, it does not only prevent the owner from imposing huge increases in rent, it also does not allow the landlord to evict the tenants indiscriminately. So, because another reason for this rent control is that in the 60s to 90s, right, there were very few low-cost houses. So having this rent control actually cater to the poorer section of the society, where actually many of them opt to rent from the houses which are under rent control. So if this rent control it's very beneficial to the society. So what did the government repeal in the Act in 2000? It's because over the years, some tenants are actually profiting from under this act, whereby they pay really, really low amount as the property value increase. So to repeal this act is to end profiteering by the tenants, and it's also to enable owners to recover possession for redevelopment of the area. And on a larger picture, the rent control has hampered the urban redevelopment and underutilized the land capital for a long time. And this repeal of the act is also to encourage investment in pursuit of economic developments. So, but coming back to the current situation, I think the government can look into impose a rent control. But because Malaysia has such a large amount of land and has so many types of building, like there are rent tenancies, the tenancy between a residential tenancy and non-residential tenancy. So maybe the government can have it specified according to the types of building. Is it residential? Is it commercial? And maybe the type of usage, or maybe it just depends on the land area, whether it's at a high value area or whether it's on a low value area. So government should take all this into account when trying to impose the rent control, and not just have one policy to cover all. So to recap, I think the consideration that the government should look into is that the suspension of tenancy agreements, and then landlord cannot terminate the tenancy due to non-payment, and the government can actually look at the rent control. So I think that's about it for the rent issues. Thank you.
Thank you, Sue. I think Sinu has a bit more to add on what Sue has to say. Please, Sinu.
Thanks, Shara. Yeah, so Sue has covered quite a lot. I just want to add on the issue of homelessness. So in Malaysia, as well as a lot of countries overseas, this issue of homelessness, it's prevalent amongst the working poor and the urban poor, because they are not able to work, but they still have to pay rent. So when they're not able to pay rent, their landlords threaten them with eviction. So you have a situation where they are basically caught between a rock and a hard place, where you can't work, you can't pay rent, and you're asked to move out, but yet you can't move out because there's a lockdown, and if you move out, there's a pandemic. So what is effectively a private issue has become a public issue. So I think in this COVID-19 bill, it's important for Parliament to pass certain provisions to prohibit landlords from evicting their tenants, and whatever that is due during that pandemic, whatever rent is due during the period of pandemic where the tenant is not able to work, that is something that should be controlled, something similar to the Rent Control Act. But it's very important to not evict anybody during this time of pandemic, because it will only exacerbate, not only is unconscionable, it's going to exacerbate the public health issue that we are already facing. And there are other areas as well, because it's not just about contract, employment, there's issue about family as well. So what do you do where families that are separated during this time of the pandemic, where children, where the parents are divorced or the parents are separated, and it's currently in family proceedings. There's currently family proceedings ongoing in court. How do you deal with that issue? How do you deal with compliance with payment of alimony, maintenance? How do you deal with issues of visitation? So that's something that the COVID-19 bill needs to deal with as well. And then you have the issue of other statutory deadline. I've spoken about limitation. Mike has spoken about the 60 days period under the Industrial Relations Act. And there are others out there. So that's something that should be extended as well. You have issue of bankruptcy and insolvency. I think we have seen some form of exemption order being made. So that's something that bankruptcy, there should be something similar for bankruptcy as well. So those are the many issues, and then you have to deal with the anticipation of a lot of disputes coming to court. So how will the judiciary deal with it? Is it more prudent to start a type tribunal to look into this type of disputes, where it's more user friendly compared to the current court process, which you would have to go to a lawyer, and not everybody may be able to afford a lawyer. So it's very wide ranging and it's very holistic, and it's something that should give us a lot to think about, and Parliament should definitely look into all these issues. Thanks.
Thank you, Sinu and Sue. I think we all can agree that the increased number of homelessness might just, worsen the spread of COVID-19. So I think rental control should be, brought back again. Next off, we have Amir will be talking about the COVID bill. So Amir, please.
Thank you, Shara. Selamat Hari Raya to all of you. Thanks to the previous speakers for sharing their thoughts and views on the areas that should be included in the COVID bill. First and foremost, we have to understand and appreciate the fact that until now, Malaysia has no COVID bill legislation, unlike most other countries. Closer to home, we have Singapore as an example. Singapore has already have their own COVID-19 Temporary Measures Act 2020 to deal with certain areas and aspects that affect the public business sectors as a whole due to the pandemic situation. At the moment in Malaysia, what we have done is that we have been using the Prevention and Control of Diseases Act, and through the regulations, that's how the government, through the minister in charge, to set out what are the things that can and can't be done during this pandemic situation. Now, we have to appreciate that the Prevention and Control of Infectious Diseases Act is only meant to deal with how do we contain or prevent the spreading of infectious diseases. The regulations that can be legislated pursuant to the Act is only meant for that specific purpose. It is not meant to cover the wide-ranging issues that have been discussed by the earlier speakers. Now, the importance of having this COVID bill is to regulate our lives, to regulate businesses, how we conduct our daily businesses, how we conduct our life affairs, business affairs during this trying period. So, Joshua has spoken about court proceedings. That is definitely one of the aspects that has to be included in the COVID bill. You need to have proper provisions to deal how do we conduct civil, criminal, or maybe even Sharia court proceeding. Mike just now mentioned about the industrial court hearings. That perhaps should be also included in the COVID bill 19 under the chapter or the segment with regard to court proceedings, because we definitely need to move on. There are matters that has to be heard, to be tried. So we need to have proper legislation. If we look at certain legislation like evidence dealing with child witnesses and certain sexual offences, whereby we have specific provisions that deal with live giving evidence through camera. So we need to have something in place. I think in Singapore, for example, they have dealt with that particular situation whereby Sharia and normal court proceedings, under what circumstances can it be done in camera? Even in criminal cases, I mean, they have to have proper provisions of how a witness should come forward to give evidence, how an accused person should be present in court. And of course, when it comes to businesses, we have a lot of businesses being affected. Contractual obligations, Sinu had dealt with that issue extensively. So you can see that those are the areas that has to be covered under the COVID bill 19, because there are so many contractual obligations that has to be fulfilled, failing which may result in a breach of contract or termination of the contract. But then again, this current pandemic is something which is not anticipated by anybody. So there need to be some sort of a temporary measure whereby contractual obligation can be suspended. And when we talk about contractual obligation, it will cover wide-ranging contracts. It could be employment contract, a business contract, SPA, for example, as been mentioned just now. So these are the areas that affects us as a whole, as well as businesses, and that has to be dealt in the COVID bill 19. A rent issue, livelihood issue, that is also another important aspect. Sinu and Sue had mentioned about right to roof, right to have a proper housing. That has to be looked into, because when we have a proper COVID bill or COVID-19 legislation, we must not only look solely or mainly in the commercial aspect, but we need also to look in the humanitarian aspect as well. How do normal people, the urban poor, the working poor, how do we ensure that their rights are being protected? How do we ensure that they will not be subject to victimization due to the current situation? Another aspect which was never covered, which I would like to mention in brief, is meetings. Under certain laws, there are certain meetings that has to be conducted. For example, the Bar Council, under the Legal Profession Act, we need to have our AGM. And of course, the Bar Council have to have their own meetings during from time to time. And we also have societies, for example, who are governed either under the Registrar of Societies Act, or even sports association governed by the Sports Development Act, they need to have AGM, statutory AGM. How do they conduct their meetings? How do they carry out their functions? These are the aspects that has to be dealt. In the Singapore COVID Bill 19, they have also mentioned and dealt with this particular statutory meetings that has to be carried out. Companies, for example, companies have to have their meetings. Do they have to have meetings physically? So these are the aspects that must also be included in the COVID Bill 19. Before I conclude, I just would like to say that we had the opportunity to pass this bill at the earliest available opportunity, which was on 18th May. Unfortunately, some people think that by passing or introducing this bill during that period is not a wise move. I really do not understand why. Tabling the COVID-19 bill is not a political matter. It is a national interest matter, a matter that affects all of us. Politicians should stop politicking. They should get their acts together, introduce the bill immediately, not by politicking and saying that, oh, I want to do this, I want to do that, I want to challenge you. We are being affected, and at the moment we do not have proper legislation that governs our lives, all other aspects of businesses during this period of time. We do have laws that govern situation under normal circumstances, but not in the current situation. So we need to have something legislated urgently. There is no time for dilly-dallying and politicking. Now, following from that, what will happen if during this period, since we do not have a proper legislation, what if somebody decides to enforce their rights under the contract by terminating contract, employment contract, or do certain things which may be unacceptable or unconscionable during this period? What law do we apply? Do we apply the normal law? Or do we have a special or proper legislation that will cover the rights of the parties during this period? So this is a relevant issue that has to be looked into. Now, if we introduce the COVID Bill 19, maybe at the later sitting, could be in July. So is it going to be retrospective? Is it going to be prospective? If it's going to be prospective, what will happen to acts or things done prior to the coming into force of that act? So this is something that the legislation has to take into consideration. Okay, I believe that's all that I would like to share. I just merely sum up some of the areas that have been shared by the earlier speakers, and I've also mentioned a few other aspects which ought to be covered under the bill. I have nothing further to add. If there's any question, I believe any one of us would be more than happy to answer the questions from the public. Thank you.
Thank you, Amir. Yes, I couldn't agree enough that we should stop politicking, and proper legislation is needed at this time. So we actually are running out of time. We ran out of time. So we only have time for 2 questions. So I'll read out the first question. During this COVID-19, is there a legal necessity to enact specific laws to provide relief and postpone on certain laws and legal obligations, like the Singapore COVID-19 Temporary Measures Act? Or can the government just announce such measures? Can it be challenged? Maybe Amir, you can take this question, please.
Thank you, Shira. Of course, I mean, based on what we have discussed, there is a legal necessity for us to enact specific laws to deal with the various issues, legal issues that have arisen due to this pandemic. So something similar to the Singapore COVID-19 Act, or maybe something more comprehensive, because based on what we have discussed, I would say that what we have suggested, what we have proposed, are far more wider than what has been legislated in the Singapore COVID-19 bill. So yes, we definitely need to have something to deal with this situation. And I think the second part of the question, can the government just announce such measures? You cannot simply, you need to act based on certain parameters. So there need to be proper legislation. I have mentioned earlier on that what the government has been doing, they're just merely piggy riding back on the Prevention and Control of Infectious Diseases Act. They enact legislation, and through that regulation, they try to justify what they have done and what they're going to do. I have mentioned earlier on the objective, the mischief of that act is solely, mainly to deal with the prevention and the containment of infectious diseases. It doesn't cover the socio-economic aspect which are affected due to the pandemic situation. So we need to have specific legislation. We cannot simply just issue announcement without being regulated, without being covered by any legislation. I hope that answered the question.
Right, thank you, Amir. We have next question. Actually terminate the agreement before the expiration of the term during the COVID-19 period, whether the landlord is legally entitled to recover the rent for the unexpired period of the term, besides the forfeiture of the rent deposit. Senior, maybe you can take this one.
Thanks, Shara. Thank you for that question. Just let me read it. It's quite a long question. So you are saying that the tenant has terminated the agreement before the expiry. Well, I think the answer here it's quite clear. If it was unilaterally terminated and by no fault of the landlord, then yes, the landlord can technically sue for the remainder of the tenancy agreement, especially where he's not able to get a new tenant in. So that would be an opportunity loss on his part. But if it was terminated for some other reason, based on the COVID-19 or pandemic, where, for example, he might want to move to a cheaper property, he cannot afford the rent anymore, then that is something that the legislation should deal with, because he might not be able to obtain a remedy under the current contractual regime, because the current Contracts Act is based on the assumption that everything is normal. There is no shock to the system like how we are seeing in the pandemic. Otherwise, yeah, the tenant unfortunately would not be in an entirely good position. But of course, everything else really depends on the contract. There could be a notice period where it allows the tenant to terminate the contract in accordance with the contract. So if there is such a provision, then the landlord is not able to sue for the remainder of the period. But otherwise, he would be able to. It really depends on what the contract says, but generally, yes. Thanks, Shara.
Right. Thank you, Sinu, and thank you for that question. So that sums up our session today. We gave you extra 10 minutes because it's Raya. So maaf zahir dan batin. We have another session next week on the 2nd, same time at 12. So stay tuned. Selamat Hari Raya. Bye.
Bye. Selamat Hari Raya.
Bye. Selamat Hari Raya. Bye.
Selamat Hari Raya. Bye.